Okay, I'd like to call this meeting to order of special meeting of Committee of the Whole. It is Wednesday, September 25th, 2024 at 5:59 p.m. Annie, would you call the roll?
Cobb.
Present.
Kuda.
Here.
Petrus.
Here.
Larson. Here. Maddox. Russell. Posh.
They're all excused. We have one item to discuss today. That's discussion of the Charter Review Commission recommendations. I almost said CRC, which I don't use that lingo. We have had one previous meeting. We're going to start. We're working on one bucket, and by bucket I mean there are, I believe, 5 divided areas. This one is balance of power. We got through, I don't know, I'd say 6 or 7 of the amendments. We stopped at vacancies. The discussion was about filling vacancies when a vacancy comes up because somebody's leaving during their term. What do? We had some varying opinions. I have since given this a lot of thought. But first, I'll hear from my 3 colleagues about this.
I did pull up, Linda Strayevsky sent, I'm sorry.
No, we're
Working today?
Yeah.
Linda Strayevsky sent me an email that had all 4 cities attached that they referred to for the vacancy issues. And so, I don't know if you want me to read, when the way my brain works, when I have to read these to understand what the example really means. And so I don't know if you want me to read these or.
Well, can you characterize where they came down? Do they all come down in the same place on this issue?
Similarly, especially South Euclid.
Okay. Similarly to each other?
No,
Similarly to
this.
You guys want to talk
yeah.
about this in the meeting?
this, we're in the
meeting. It's not, yeah, so we're recording and not live.
Okay, very good. Very good.
Very kosher.
Thank you. Thanks. I looked up to see the light.
Yes.
This is very unusual. They've already started.
Let the record show that Bill Hanna has joined us, Law Director.
Yes.
So, I don't know. Do you want me to read like the example from South Euclid or?
Yeah, read the one that you think exemplifies the 4 that you looked at.
Okay. They say, South Euclid says, a member of council appointed to fill a vacancy shall hold office for the unexpired term of the member in whose office the vacancy occurs, or until a successor is elected and qualified. A successor shall be elected for the unexpired term at the next municipal election.
Okay.
And primarily the rest of them referred to the next municipal election.
So let me give you, if you will, my rationale for coming down in the same place, and then we'll deal with the other issue, which is how long do we take
Same place as where? Sorry.
Vacancy.
as
this?
as the South Euclid. Couple of things. One is the empirical evidence. What we've looked at in the last few years is that when you and Posh have run, you've been unopposed. Okay, so that does not accomplish the competition thing. I mean, and it's anecdotal, but I'm going to couple it with some other things here. When Josie Moore ran in 2021, there were 6 or 7 people in that race. That was during a municipal election. It was a competitive race, and so that's kind of another thing I kind of filed. So there's other thing is when somebody gets appointed and they're in an even numbered year, they're running in a non-municipal election year, which could be an even numbered year. In the case of Jim Posh, that term ends up being 3 years. The unexpired part turns out to be 3 years. So they actually serve longer without an election. And then what would I say lastly? I think I had one more reason for this. It's just my opinion, I guess, that, I know what the other thing was. If you just get on and you have like no record, you haven't done anything, you can't really say much. The first thing you have to do is start going and getting petitions signed. At that point, there's really not much for, people could say stuff if they just happen to know you from before. But I'm saying, actually on council, it's very difficult to establish anything for the candidate or for the person who filled the vacancy, or, for the person, that might be in opposition. Go ahead.
Thank you, Mr. President. Just to clarify, so whenever someone is appointed in the first year of a 4-year term, like is the case with Jim Posh, while the next regularly scheduled election would be 2027 in Jim's case, for example, currently he'll have to run this year. So he'll run this year and either be retained or not retained. And then if he is, then the next election would be in 2027.
But just to interject, if it was the way South Euclid did it, he wouldn't run in 27, he'd run next year.
Right, exactly.
Mhm.
And
Yeah.
for clear, if I could, Mr. Law Director, I'm not sure, maybe you know this, maybe you don't, but for example, this year, in the case of Jim Posh, does the city have to pay any amount of money to like the Board of Election to have Jim on the ballot?
I don't know for sure, but I know when we've last looked at this, there's a difference between a special election that occurs simultaneously with another election and a freestanding special election on its own day,
Okay,
which is much, much more expensive because of personnel and so forth.
so I guess
We could
I'm
figure
just
that out.
wondering whether there is any sort of like additional cost burden to us having this election in a non-municipal election year versus if we were to have it next year. But if there's already going to be candidates on the ballot, maybe it's a case that we don't have to pay them anything more.
Yeah, it's not,
Don't
there's
use
no, there is an expense every time you put something on, but it's very low
Yeah.
when there's already an election.
Yes, agree.
Okay, so are we in agreement that the municipal election year is the better year to do this?
Yeah.
And then on the days, on the number of days we take to make the appointment, right? Currently it's 45. I'll tell you why I'd like to change it to 60. I like the screening process, and especially I think by waiting till the next municipal election, I think we owe as much or more scrutiny, to the screening process. So certainly we would not want to go any lighter on the scrutiny. And we know that we, for Gail and Craig, we've had to do it twice, and you've had to do it once. That 45 days, even the last time when things went pretty smooth, it came right up to it. And here's the reason I'd like to go to 60. When Janine Boyd resigned, we had a meeting about, and we laid out a timetable. Day one, it was day one. And I said to everybody, these last 2 weeks especially, just keep this in mind, we're gonna need to be here because, we may have to be really active. And I'd say 5 of the 6 of us had to be somewhere else those 2 weeks. Now, that could be an anomaly, but by the same token, just knowing that it can happen, and that's when everything went relatively smoothly. We did have people drop out that's the other factor. People drop out, it changes the dynamic, I could tell you it changes the way I think. I can't speak for other people. And given just those factors that are real, and they're gonna happen again. People are gonna put their applications in, some people are gonna drop out. It's happened every time I've watched this, people have dropped out. Now, I don't know about the people having to go out of town, council members having to go out of town, but that little extra breathing room, I think, is necessary. I don't think 15 more days makes a tremendous difference about, to the public. I mean, certainly we might hear from people, but that's my feeling.
These, of the 4 cities that the commission polled, Lake or South Euclid only does 30, which I think we all agree is too little time,
Yeah.
the way that we like to do it. Lakewood has 60, University Heights does 30, and then Shaker Heights does 60. And in my mind, it still felt rushed at 45. I mean, aside from the fact that we had problems scheduling people, and the other thing of that is we have to make certain, just an aside, when we have a vacancy we're trying to fill, that we state when that person needs to run for re-election. Because
Yes.
that was why we lost some of the applicants.
And there was another thing that Lou Radovojevich said that we needed to do.
Conflict of interest.
It wasn't conflict of interest, but he said,
He has business with the city.
I thought he did.
oh, maybe that was it. And there were a couple, we need to make notes of this, that, yes, that and Lou's
Oh,
comment.
time commitment, he talked about.
Yeah.
The time commitment, yeah, that there were things that were not clear and upfront that should have been there. The 45 days, I think, was there's several 30s. If you look at communities, there's many that do 60, and I think the 45 was the compromise. But given that our tradition with the League of Women Voters, which, I mean, I find that valuable, and I haven't heard anybody say, we don't need to do it. I mean, please say that now if you think that.
I would say for the league also, it was hard for them. They worked really hard to get everybody scheduled. It was like,
Especially when it's right around the end of the year.
Yeah, it's like,
holidays, whatever. So the 60 days would give us all a little bit of breathing room if we want to continue to, and they're willing to continue to do the interviews for us.
Mr. President, if I might, as you know, I'm a fan of 30 days as a general matter. And I think it's kind of the prevailing number out there. But Cleveland Heights has used and has appreciated, Cleveland Heights Council has used and appreciated the League of Women Voters. And I think that trying to cram that process into 30 days or 45 is challenging. And so for that reason, 60 could certainly be an appropriate number in my view, for what it's worth. The question I wanted to ask is if the charter is amended to provide for virtual meetings by council, does that impact your feeling on this at all? And given the factor of the League of Women Voters, maybe it doesn't, but I just wanted to throw that out there.
I mean, that does potentially speed things up. Could speed things up, yeah. But
You don't have to take the full 60 days if that's your rule.
I really like in-person interviews for this position, for not just this, but
For the finalists,
yes. Well, we don't
Not
use that
finalists.
word, but we could strike that from the record. No, it's not the third rail or anything.
the light's not on.
But Craig, you've been kind of quiet.
No, I'm listening.
No, I know, but are you 60 or keeping 45?
60 days is fine.
Okay, and
There's nothing says that we need to take off 60 days. If we can do it sooner, we'll do it sooner.
that's absolutely true. I would never advocate for taking 60 days no matter what. Hopefully, no council person will, because
I would say that a city that, I can't remember which one it was, they have 30 days. But the last vacancy they had to fill, the person gave them 3 months. We have not had that luxury.
yeah.
mm,
I don't
Oh,
think,
3 months notice.
notice, yeah.
is that something you can put in a charter? not 3 months necessarily, but I mean, just some kind of,
Heads up.
Not like an
well,
objective
some kind of
anything.
requirement that you give a certain notice. Let's just say a
I-
certain,
So without having researched it, I think you could probably define when a vacancy occurs in such a way that you could build in the power of council to declare the vacancy and, make reference to the date upon which somebody conveys their intention to resign. But I think it's fraught with more complexity than it might be worth. And if you give yourselves enough time, if 60 days is enough time, then the sudden resignation hopefully is not something that needs to throw you off your game.
agreed.
I think that would be easier than trying to make other adjustments.
So I'd like to throw something out here as a suggestion for how we review these documents. So this document alone is 22 pages long, and we are on page 3. And the last meeting that we had, we got through like 2.5 pages of this. So I'm going to propose that for each thing, if there is no disagreement in what's proposed, that we could always speak up, but we do our best to try to limit the conversation and continue to the things where we don't have consensus on something. So what do people think?
No.
Just in the interest of,
No, you did the math, and it's fair. I mean, I wasn't planning on belaboring this one, we actually tabled,
okay,
kind of officially said, well, we'll table this until the next meeting. But so 60 days, municipal elections,
so as written, I think,
so that's,
as proposed.
yeah, so that's as proposed, okay.
So I had a question from a non-member standpoint. And you're looking at Article 3, Section 3 at this point, right?
Of the document proposed amendment number 1.
Yes. Well, I hope so.
Does it say at the top proposed amendment number 1?
It says the first amended charter. But the language should be the same, right?
Hopefully.
Other than page numbers, maybe. So what I'm reading is with respect to vacancies, it's got the change from 45 to 60 days after the occurrence of the vacancy. And then at the end of the first paragraph, it says that the person appointed to fill the vacancy shall serve until the first to occur at either the expiration of the term of the member who vacated the office or a successor is elected and qualified. I think it's possible that you could get rid of the first to occur there. And the reason I say that is that there's a revised code provision that says that a public official serves until a successor is appointed and qualified. Because the idea is that public offices shouldn't be empty unnecessarily. So that's not a major point necessarily, but I wanted to throw that out there. And when you get to the point where you're looking for any tweaks from the law department, that's something that I might suggest to you to just clean it up a little bit. And then we get into a successor shall be elected for the unexpired term at the next regular municipal election if such election occurs more than 2 years prior to the expiration of the unexpired term and the vacancy occurs more than 90 days prior to such election. Otherwise, the individual, I think this language is a little awkward, shall serve the expiration of the term.
I agree.
So I think I would suggest that you say something like shall serve for the balance of the unexpired term.
Yes.
Remainder,
Something
yeah.
like that. And then I think looking at the language that, or thinking about the language that Councilwoman Larson cited, I think the next several sentences could be simplified substantially.
Yeah, I see that.
I think that you just want to say something like the successor will be elected for the unexpired term at the next regular municipal election. That's pretty much it.
Yeah,
Because trying to figure out whether it's the year before the election or the presidential election, the year after, and then I didn't understand the assertion that the number of votes needed to win a seat would change. So maybe there's something there that I just don't understand, but I think that's something that you might clean up.
Yeah, without speaking, I mean, if that's not in the, I know they have somewhere in here explanations of how they arrived at all this.
Yeah, I didn't look back at that.
I didn't either, so.
But in terms of substance, there are no changes,
I-
right?
Right, and we want, but we wanna,
I don't
You
know,
wanna,
yeah, it's probably no substance.
we wanna simplify
I think
it.
you want it to be clear
And simple.
and simple to the extent
Well,
possible without, reflecting this, as I understand it, with any changes that you guys decide upon.
They're just not overly verbose.
Yes.
Yeah.
So how, like, are you making notes on like these things that we eliminated for redundancy or whatever? Or do you need to have us track what we were talking about tonight? Or how does that work when it finally comes back to you?
I'm expecting the council clerk
Oh.
to have, well, I am making notes, and these are some of the notes that I made,
Okay.
so these are things that I wanted to raise.
Okay.
So I'm just putting an okay here to tell myself, yes, it's okay to revise this without changing the substance.
Thank you.
Mr. President, if
Yeah.
I could, so just to clarify, my recollection was that in terms of process for this, we would, through a series of meetings, take a temperature check of council members on each of these things. And then once we say, okay, A, B, C, D, we want to move forward with these, then the law department would take a look at it and say, okay, these are areas where we think that we should simplify this language, or this is how we think that we should bucket this stuff together in terms of amendments. Is that still, is that what people have in mind for this process?
Yeah, we were gonna try to get this done by January.
Yeah.
Which is maybe
So
not.
right now, we're doing the temperature
Yeah.
check to see
And
where we
then-
are.
And then,
And then the law department can
Right.
say, okay, this is how
And I
put it on.
I'm sorry to interrupt. I can shut up.
No.
I felt like maybe it was useful to at least raise questions like this as we go, so that if in 2 months I say this, somebody doesn't say, we've never heard this from you before, pound salt.
I don't wanna expedite this with the idea that we're gonna come back and pick up little things that our minds are gonna go onto so many other topics. I wanna do this as we go.
Okay.
Maybe a little bit laborious, but that's what charter work is. It's laborious and it's detailed. And we have varying opinions about that, and unfortunately, we're gonna have to default to the people who want to do this with a fine-tooth comb, because you can't I don't think we should ask that of each other. Well, I think, let's just go forward with all the recommendations versus the people who say, no, let's look at every one of these things and get it right. I think we kind of have to default to that, even if it's just a couple people, because what we're going to end up doing is turning something over to the law department and then having to do it after that,
And that's where I've been thinking that having this type of conversation, I don't necessarily have to jump in on a whole lot, but when it gets to that point, we'll make it easier then to produce something that is closer to what you were looking for and that reflects the concerns that I've seen.
Okay, next is salaries, and I see that the two things have been crossed off and kind of consolidated into one. So this is 3.4. I had no problem with any of this. Anybody else? Then the appointments, 3.5, and speak up if I'm going too fast. 3.5, this was done, this council clerk amendment. This was, something worked over the last couple of years. So,
Excuse me, President, couldn't
Yeah.
they add that? It sort of sticks out like one sentence, one paragraph. And it's in the charter, right? It's already something that the commission is suggesting we don't need to change.
yes, we changed this when we took it away from the finance director
Okay.
and the, mayor's office.
22.
Okay,
Yes.
Yeah.
Yeah, that was the first
so
year.
this
I
gives
was-
council the authority to make that.
Yes. And then formally in 3.6, and you can see it crossed off, except for the purpose of inquiry thing. So we'll, when we get to I don't know, it might be a couple of pages down, that comes up. That now comes up at the end. So just kind of put the pause button on that.
Did you say 3.6?
Well, the except for purpose of inquiry was formally in
Was,
3.6. So that's why that's crossed off and kind of resurfaces in a 3.12 later on. But for now, let's look at what is the new 3.6. And this is about meetings. Council shall meet for the purpose of organization on the first Monday in January. This is the standard in every charter, how council gets organized. I have no problem with any of this. Anybody else?
Just a question.
Yeah.
The commission put that in there so that if we needed to go virtual, again, because of another pandemic, somebody forbidding that should happen, they want to make sure that we have the flexibility to make our meetings virtual again? Was that what that allows us to do?
I think it was beyond that. Am I
Yeah,
right?
I think that's right, except that it's broader in
Yeah.
intention to provide that ability, which might be useful even in the absence of a pandemic. You could have a blizzard.
Yeah.
You could have, there could be lots of reasons, or it may be that several people are out of town, but you need to have a meeting. And
You have a quorum.
Hybrid. So my only, and I think it's a good thing, it has to be in the charter. I think the one thing that I might suggest when you get this back from law is to build in some of the protections as to the requirements for those meetings, basically lifted out of what the state law provided during the pandemic in terms of accessibility and how you post people's ability to, find the meetings and patch in and things like that. And then kick the finer details, as this does, to an ordinance.
And it doesn't say anything about being allowed to vote if you're virtual. Does that need to be stated?
That's the kind of thing that I'd like to put in there, that yes, if you're in compliance with these things, that you are present for purposes of quorum and that you are able to vote
Yes.
and participate in discussions.
Question, is that something that would need to be in the charter, or can we do that by an ordinance?
I mean, my recommendation would be to have that in the charter, because there are folks out there in Columbus or places south of here who may be more skeptical of the ability of a Cuyahoga County municipality to meet virtually. So I think the arguments for doing that and for exercising your home rule authority are stronger if it's in the charter.
I'm for that because I see, people's lives and, just trying to be realistic. Any objections to that?
No.
All right, Craig?
No, I'm fine with it. Did the internet just go out?
No.
So general provisions, 3.7, council determines its home rules. This is just very standard. And we have quite a bit of 111 companion ordinances, if you will, for that, how we, council organizes itself. Then there's council's,
President,
yes.
I just want to make the point that first sentence, part of the first sentence in 3.7, the council shall determine its own rules and order of business. I've had people ask me why we don't have our own rules, and I would just like to suggest that they're seeing it's in the charter and they'd like to see us do it. That's all I'm saying.
Well, that's not true. We have, in 111, we have rules, and we have Robert's rules.
Right.
And it says that. So So this is semantics right now for me.
Yes.
Um,
Just nothing changes there. It's just people are looking at that as being something that we put together for our council that gives us direction and governing practice. So this person that I specifically spoke to wanted to see us have rules above and beyond Robert's Rules of Order.
And above and beyond chapter 111 of the codifieds. I mean, you guys have had that conversation over a period of a
Yes.
couple of years. You certainly can do it, but when people say that you don't have any rules, which almost sounds like you're lawless, I mean, you do have rules, and the council president's right.
Yeah.
Chapter 111 actually covers quite a few things, including things like, abstention versus recusal and how those things happen, and there's a lot there.
So shall determine its own rules. Is that a little too, should it be may? I mean, only because, is it saying we need to do something, well, it's not really saying we need to do something above and beyond what's already there.
It's not, and I don't think there's anything to be gained from changing that.
Okay,
I don't think you're in default of any obligations that you have under
I
the
see.
provision at the present time.
I'm glad you brought that up and, keep doing that. Subpoena power, here's something new, okay, 3.8. I'm gonna read it. The council shall have the power to make investigations concerning the affairs of the city. And in the course of any such investigation, the council shall have the power to subpoena and require the attendance and testimony of witnesses, and the power to require the production of subpoena of any books, papers, public records, or other documents, evidence pertinent to such investigations, inquiries, or hearing. The council president shall have the power to administer oaths and affirmations and to take testimony relative to any such investigation or hearing. The only thing I wrote down here is, shouldn't the law department do the oath part? But
They could.
Don't you need to be a notary at least to administer an oath?
Yeah, I think there's a question to look at there.
But what are the enforcement powers for failure to respond to the subpoena?
This is your temperature taking session. No, I think that's a legitimate question that ought to be looked at. Yeah.
well, would that be done by ordinance, the penalty for not, or do you usually put the penalty? I don't remember seeing penalties in charters, but
Right.
except for like,
It could be in an ordinance, it could be in the criminal code if that's the way that you wanted to approach it. Typically, and Craig's used subpoenas in his practice, it's considered a court order. And so defiance of a subpoena has, consequences. I think it's difficult I'm not saying it's impossible. I think that there's a question about how you try to elevate this type of administrative subpoena essentially to the same level.
I've seen this, I think, in the county charter. Does this ring a bell to you? Maybe not every word, but,
I would have to look, yeah.
okay.
I'll just speak for myself. I have some concerns about putting a subpoena power in the city charter. I think it's got the potential for abuse. Who is going to determine whether subpoena is overly broad, burdensome, and the other, matter about jurisdiction to enforce it and penalties?
And the scope is confined to investigations concerning the affairs of the city.
What does that mean?
Well, it means you can't subpoena somebody to find out what's happening in some private business dispute.
Yeah. Affairs could be a broadly defined term. Did they offer any reasons for that in the? I
I'm
didn't go
looking at
back and look.
I'm looking at the report. I've got it pulled up right here. You want me to read that paragraph?
Yes.
Okay. The council, the mayor proposed that the commission consider adding to the charter subpoena power for the council. Although the Ohio Revised Code does cover this, The commission did accept the mayor's recommendation, see section 3.8 of proposed amendment 1. The mayor also proposed the charter include a grant to the mayor of explicit investigatory power as the affairs, there's your word, of any department or the conduct of any officer or employee. The commission decided not to include such a provision because the charter already grants to the mayor authority over administrative staff. So that's all they say about what they put in here.
So it may be in the county. That could be someplace where the mayor has run into that and looked at the ORC about it.
It is in the county, I just found it.
Yeah, I've read it.
In Ohio Revised Code 70521 speaks to the same general concept and then goes on to say that if a witness refuses to testify to acts within their knowledge or produce papers or books in their possession or under their control relating to the matter under inquiry, legislative authority may commit the witness to prison for contempt. So, yeah.
I guess this is an area that I know nothing about. So could you help me to understand how this is different from our current authority? Like, what authority do we currently have? Maybe that would help us to judge whether that's sufficient.
Yeah, I didn't prepare to discuss that tonight, but there is authority for legislative authority investigations, I think, short of subpoena and imprisonment as well. So I could provide additional information about that. Is additional authority in the Ohio Revised Code for that. And so since the charter doesn't limit that at present, and it's not been limited by a council adopted ordinance, which council could of course change anyway, I think that that exists.
What's the added benefit of subpoena power?
I don't know. Well, so if you can put somebody in prison for contempt, the added benefit is compliance, obtaining information. But it wouldn't have to be, but you might be looking at employees and officials if you're talking about affairs of the city.
Mm-hmm.
There could be, again, other people who've done business with the city and things like that, who might be involved in affairs of the city. But I haven't run into this. I'm not familiar enough with it to tell you pros, cons, what the details are.
I guess the reason that I'm asking is that I'm thinking about, what it is that would be requested. Much of the information is already a matter of public record. They're already public documents. So, how would this make it any different than what we already have? Can we get what information we're speculating here about what a future council might want to get through the powers that already exist? Or is it the case that we need this in order to get that?
I mean, for me, the question is, if council is going to exercise oversight authority and the administration could say, we're not going to say anything, we're not going to give you access to that, then the question is, what is it authority if you can't compel somebody to answer questions? And right now, we can't compel them to answer questions. Administration just go, we're not doing it.
Mm-hmm.
And I mean, that's the question. I mean, if you believe that oversight is an authority that council needs to function properly, that it's a legitimate authority and that it's a legitimate function of council without having to without compliance being mandatory, I don't know exactly what that is. It's just voluntary.
My general position is that I think that we should send these as recommended to the voters. So I think that that's going to be my position on this one.
Is everybody okay with them changing this to the law director administers an oath? Because I I didn't know about what you just said about the having to be a notary, but
And I could be wrong about that, but I don't know.
The statute, I think, I'm sorry to interrupt, Councilwoman, I think the statute indicates that any subpoenas would be signed by the presiding officer of the legislative authority or the chairman of a committee.
Is that from the Ohio Revised Code? Which section is that?
70521.
If I could, and just, you know, the concern about being able to bring in someone from the administration if they were not answering questions, I think we'll get to that in 3.12. Not to jump ahead.
no, that's.
If the purpose of, you know, is being able to compel people in.
Oh, yeah, I mean, I know this, I definitely have to,
And if they're public records, you know, there's an obligation for the administration to provide us public records.
Well, I guess one question. So when filling public records requests, the city could say, this is too broad of a request, and it can be difficult to get documents that you're ultimately interested in. So is there something that would enable this body, if it wanted to effectively get the documents that it's looking for?
see, I don't look at this as about documents. I look at this as about if we want answers to questions from people, from personnel.
Mhm.
You know, I mean, I think I would agree with, I'm not sure exactly what you're saying, but I would agree with you that we have the access to the documents.
I guess maybe that was a question for Councilman
Public.
Cobb.
But
So while documents might be public records, it can sometimes be difficult to get them. So is there a way, I mean, maybe 3.12 does sort of address that. Is there some way that we could ensure that we get the documents that we want without being burdened by or restrained by a response that says something like that's too broad of a request?
I don't know. Let me look at that the Ohio Revised Code section on subpoena power. And then, you know, if we can revisit this,
Yeah.
I'll take a look at that again. Again, my concern with the subpoena power just generally is typically in a courtroom proceeding, you have a judge that's able to make decisions about the lawfulness of the subpoena, whether it's too broad, whether it's too burdensome, whether your request falls within something you're entitled to get, whether it's a privileged document that doesn't need to be turned over. There are all kinds of issues that come up, and I just don't know that in the context of a city responding to a city council subpoena and bringing someone in front of a council committee, whether we're equipped to be able to make those kind of decisions or not. I don't know.
Well,
I think-
wouldn't the law director kind of help with that? I mean, in the case of, you know, we're gonna subpoena somebody, wouldn't we be running that by the law director?
Not this law director. I mean, I think that it does potentially raise questions of conflict depending upon what you're doing, right? Certainly I can't imagine that a subpoena would be issued without the law department being involved. But with respect to Councilman Petrus's drawing a distinction or inquiring about a distinction between a subpoena and a public records request, I think there's something to that, but I don't think it maybe is as stark as as it might seem on the surface. Ohio Civil Rule 45 is the civil rule that governs subpoenas, and anybody who receives a subpoena can move to have the subpoena quashed or to get a protective order for reasons including there's not enough time allowed to comply, that it requires the disclosure of privileged or otherwise protected matter, that it requires the disclosure of a fact known or an opinion held by an expert, retained, blah, 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 or that it subjects a person to undue burden, which is maybe even, a broader standard than overbreadth. I mean, there are rules that courts apply to decide if something really is an undue burden, but the point being there's a lot of gray and a lot of lines that would have to be drawn to decide, how effective this is versus some other mechanism. I don't know what the answer is sitting here, but I think it's stuff we would want to work through.
And given this Ohio Revised Code Section 705.21, is it necessary that we have this in our city charter? Or because we're a charter city, does that mean that we need to have it in our city charter to be able to take advantage of it?
No, you don't give up. You don't give up rights that exist under Ohio law by having a charter. But you have the ability in matters of local self-government, that are pure, to do things that are different than what the ORC says.
I was totally unaware that this provision was in here.
I think this probably comes in the category of requires further study and reporting for you guys to then make decisions.
I agree.
I do agree. I think we have to look at balancing if there is abuse of any kind or questions that we have where money's being spent on things, we're not sure. If we don't have the power to get answers, that's ironclad. And I guess maybe we do. Maybe the state already has this. Then the question is, so we're balancing, making sure that we have it versus if we don't have it, and it looks like we do, but if we didn't have it, would we be able to do oversight properly of the administration? And if it's unnecessary, or this just kind of strengthens, and I don't know why it would strengthen, why something in the Ohio Revised Code wouldn't be as ironclad as something in our charter. But if that's what we're going to look at, then I'm okay with putting this off. But I think those are the things we're trying to balance. Emergency measures, this is also new, 3.9. So, Mr. Law Director, what do you think of this? I know that this is a complaint that we get that I think the Charter Review Commission was trying to give some clarity to.
I don't see anything that is inconsistent with the general legal requirements for an emergency, although, when it comes back to law, I want to look at that closely to make sure that we're not limiting in some way council's authority to adopt emergency legislation. But looking at it, I don't see that it necessarily is. So I'm not sure I have an objection on that basis, but I would say I don't think this is going to make the public any happier.
Well,
It's already in there in different places, and it's the doing of the thing, not the definition of the thing that bothers people.
If I could read from the letter that they sent explaining why they did this. The commission agrees that council and the administration could and should be more judicious in the use of emergency measures procedure. But the commission decided to retain the feature in the charter, section 3.9, proposed amendment 1. The emergency measures concept has an accepted meaning under Ohio law, which can be important in certain circumstances. Recognizing the benefit of more effectively communicating to residents is what they're looking for.
That's what it looks like.
The rationale for an emergency measure. The 3.9 adds some guardrails by requiring a supermajority vote of 5 council members to pass emergency measures.
But that's already required.
So
So again, I don't have any objection on those bases. I would encourage you, to the extent that what you just read suggests that somebody was contemplating getting rid of that authority, I would say you would never want to do that. I mean, I think council, and I think it's good to communicate about it and to be able to explain what the emergency is. And, when the mayor took office, having been on council and heard these complaints as well, he proposed some language changes to our sort of form emergency ordinance and clause that we tweaked a little bit to make sure that it worked, but I was satisfied that it does. And I think it does explain the immediate effect issue better than the old language did. But an emergency also deprives the public of an opportunity to do a referendum on a piece of legislation. And, so it should not be abused. On the other hand, when you have a lot of routine things, you have contracts, you hear all the time that government should operate more like a private business. You guys have a 2-reading rule. Most cities operate under a 3-reading rule, which means you're looking at a minimum a month to a month and a half of readings after legislation's developed. And then if you don't have it adopted on an emergency basis, you have a 30-day waiting period afterward.
Yeah.
So you're looking at like 3 months to do a simple contract. And I don't, really the public doesn't want that, but
At the same time.
but right, so you guys have to become adept at
A
sort
lot of
of
cities do.
having those discussions.
Yeah, Newburgh Heights did everything on an emergency, and they just said, and declaring an emergency after everything, which doesn't
That's what-
explain, that's why we,
Well, it's explained there will be, I'm sure that they did it right and there
Oh,
was
yes,
an explanation.
correct. But like, when you just read it
But
off.
not in the title.
And the title, it just says declaring an emergency, and I was like,
But part of that's just
Standard
on
way.
me,
It is.
like, requiring a cover sheet for
No, I
anything
don't.
that's an emergency.
correct.
And verbally explaining,
Yeah,
to, when we do public readings, but, go ahead.
Yeah, this language does not track what the Ohio Supreme Court has said about what qualifies for an emergency ordinance, does it?
again, looking at it at the moment, I don't necessarily see something that troubles me in that regard, but I'm happy to talk about it.
I'll have to pull up that Ohio
Are
Supreme
you
Court
saying it's
case.
inconsistent? or-
No, I think this is narrower than what the Ohio Supreme Court says.
And that's why it needs to be looked at, yeah.
Okay, so nobody has a problem with it being in there as long as it's worded properly, I guess. I don't know, that's a little nebulous, but. Yeah. All right.
I want to look at that Ohio Supreme Court case because I do think that this is narrower than that. And arguably, some of these contracts that we're needing to pass wouldn't meet this definition necessarily.
Okay. So we will revisit this as well then. And then 3.10, public utilities and franchises. The only thing I wrote in my notes was, where is this from? Like, where did this come from? Because I read it and I was like, Kayla, you have that handy?
I'm trying to find it.
3.10. I don't have a computer.
3.10, right?
Yes.
Mm-hmm. And interestingly enough, I don't see it in the letter.
Public utilities and franchises.
No, I'm not seeing that. They went directly from 3.9 to judicial powers of the mayor.
Are you able to do a search?
Yes, I, let's see if I can find it.
Um,
I don't know anything about this, so that's why I wanted to see.
Okay, here's the chart, because this is where they did reference it. The change was made on this section because 3.10 eliminates the previous section 3.10 with its contents now covered in Article 10. expands franchise provision formerly in Article 10 to include public utilities as well as franchises. And to state the authority of council to set applicable conditions and to renew them. Continues prohibition against granting a franchise or regulating a utility by emergency ordinance. So they're trying to make sure we don't authorize something on an emergency basis that really requires much more study. And honestly, I was kind of startled to see it in here.
And then the last sentence, you know, in no ordinance making, amending, or anything doing with a public utility franchise may be passed as an emergency measure. You know, so they just don't want anything done hastily with public utilities.
Yeah, or franchises. Yeah, I'll have to read the report. I'm not sure what problem was being solved with this.
That's,
But looking at the language of prior Article 10. And then this language, I think, is what, you know, law would want to do when this comes back to them.
so, I know we're kicking the can a little bit here and there, but 3.11, this is the president and vice president of council. Not really much has changed here. Well, except for section B. I mean, section A, it's just, you know, municipal election instead of every 2 years. It's the same thing though. I'm taking that shall be determined by an affirmative vote, just in case it says at least 4 members. We cross that off. So that implies that it's just a majority. That, Mr. Hannah, is that true? It just kind of defaults to a majority if it's not 4 members.
Affirmative vote.
Yeah.
It's like, it's kind of weird to, you know, cross that off and not put something else there.
I mean, yeah, so then you just default to your typical voting rules, which are in your rules in chapter 111. And I believe say 4, unless a larger number is required. I can pull it up.
At least in the section B of 3.11, they worded it when they're talking about a president pro tem shall be elected by the affirmative vote of a majority of the council members present.
Yeah,
Would
present.
that have clarified that, the first paragraph as well?
That seems to be why would you put that in that paragraph as
Yeah,
well?
be
Yeah.
consistent.
So, everybody okay with that?
Under 111.13, action of council, without something being provided to the contrary in the charter, it says council shall act by ordinance or resolution duly adopted at a regular, special, or emergency meeting. Each ordinance, resolution, and motion shall require the concurrence of at least 4 members for passage or adoption. So that's your fallback rule.
Okay, but it's members, I mean, so if we put members present, we're okay.
This
Because,
is 4 members.
So regardless of how many are
Yeah.
present.
If you have 4 people present, it has to be unanimous.
okay, do we want that?
That's what it is.
And that's your current rule.
But I'm just saying, considering we're doing
I
something.
mean, I don't know why they took 4 out, because an affirmative vote, you know, arguably could be 1 as an affirmative vote.
Yeah.
I would think in this circumstance, we should have 4 people who agree, because this would be a difficult thing to do.
Yeah.
right? It's not,
Again, I'm not sure why,
Yeah, of the majority of the members present.
what's being,
And it's, you gotta have the majority.
I guess what you guys are asking is why have it say the affirmative vote of a majority of council members present in section B and not say that in section A?
Right.
Wouldn't it just be the same thing?
I would think that would be consistent.
And if that language were passed, would we have to change the ordinance? Well,
no, it would override.
it would override it, right? Okay. Yeah, of course. Is everybody okay with a majority of the members present? Because I don't know how you function without doing that. And note that this gives our clerk of council a little bit of power.
I mean, philosophically,
Go ahead.
and from a
about time,
practical political standpoint, one reason there are sometimes specific numbers of votes required is to avoid situations where somebody could abuse a system by saying, hey, these folks are out of town, we're gonna call a special meeting real quick, a majority of us is 3 or 2, probably can't get to 2, but and do something that otherwise you couldn't do.
Because 2 people could call a special meeting.
That would never be a majority though, unless you'd have to have 4 people to have a meeting,
Still have to have a quorum.
right? Yeah,
Thank you.
but that could mean that 3 is a majority of 4.
Right, that's right.
So that's one reason that a lot of charters and rules will have, 4 as the fallback.
What do you guys think?
I think we need to have 4 in there as we are a body of 7 right now. If quorum, it means that the majority of people are in the room when this kind of a decision is made. I'd like to still leave it in.
I mean, in the report, they don't have like a section that offers a clear and convincing reason for changing it. So maybe it's the case that this was an oversight, I'm not sure. But in the absence of there being a couple sentences saying, oh, we ought to change it for this reason, I agree with Gil.
We need a lawyer to speak up. A lawyer member.
I don't.
And then if you
I
keep
don't-
4 in A
I hear
or
you.
4 in
understand the
B,
reason for their change.
Yes.
consistency.
I go with what the law director recommends on this. I'm not wrapping my head around it.
So you would just leave it the way the whole paragraph read beforehand?
When you say beforehand, do you mean what
At
it is
least.
today or what they're
Yeah.
recommending?
At least 4
At least 4
of its members.
So subsection B language with the majority of the council members present kicks in when the president and vice president are both unavailable, right?
Correct, so you'd
So you're
be,
down to 5, but it
5.
still allows 4, it still allows 3 to be a majority.
right.
You could also have a vacancy on council.
Right, okay, so that, I
In
would
addition-
leave that then, the way they wrote it, and then keep 4 in part A.
Right.
Is that what I'm hearing?
Or quorum? With quorum?
I would say, yeah, that's an interesting question. So I think this is one that should,
Revisit.
get some further
We're
attention.
visiting a lot lately.
Well, because I think, it's important to look at, as the councilman said, what they have said or what
Yeah.
they didn't say, maybe it's compelling, maybe it's not, but it's important to look at it. And then just to make sure that it works.
And maybe that's why they said by an affirmative vote, because they were looking at all these scenarios where you have fewer people that are actually on council at that moment for what, it could be an emergency, it could be a disaster, whatever.
But in that case, I think the rule is still 4.
Yeah.
Because of your other rule.
So are we like leave A alone, leave A the way it was,
The way it
and
was,
B will make the changes?
I think
Or
that's
look
what we
more
want.
into it.
Consider it, yeah.
Okay. So,
That's what I have. You
okay,
guys tell me.
and check, okay. All right, here's the big enchilada, 3.12.
Thank you.
Nice.
Thank you so much.
So I read this, pretty sure I know where they're coming from here. It's aspirational more than, the first part, and the second part is pretty specific. There is one, so the fourth line, in order to support council's legislative and constituent services functions. So our legislative functions are previously in the charter. There's constituent services is what I would call a informal. It's an informal role that we have. It's not a formal role. I think it's real. It's not made up, but for the purposes of the charter, I don't know. I'm not sure about having that in there.
I really like the inclusion of this. It's the next sentence that I especially like.
You
When-
like constituency services?
I do,
Okay,
yes.
go ahead.
So it's the next sentence that I especially like, and I'm glad that it begins with when appropriate, because it's the case that, not every situation is appropriate for us to intervene in. Members of council may serve the residents of the city as advocates through whom residents can seek the services of the city. So we all receive emails on a regular basis saying, hey, there's this house on our street that has this old mattress sitting out on its tree, blah, 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 blah. And then that's, where I will go to the Mayor's Action Center and say, hey, Todd, there's this thing, blah, blah, blah. This just sort of puts in writing what I think many of us are already doing. And I think that that's the role that residents sort of expect us to be able to play for them, to advocate for them in.
So there's an aspirational paragraph, and then there's some substance. That's the way I look at this. This kind of goes back to Georgine Wheelo's testimony, in front of this Charter Review Commission, that we should make the charter fit, Cleveland Heights. That's what we should be thinking about. And I think that's where this is coming from. There's been observation, and they're like, what are we going for? And I think this does capture. I don't have problem with the, certainly with the constituent services part. It's just that, do we want to have aspirational language in a charter? I'd look at the whole paragraph.
I think my view is that I think that it's appropriate and fits the expected role and the role that we currently fill. So I'm comfortable with it. Do others think?
The only thing that's got me off guard a little bit is 3.12, section 3.12 is titled Council Interactions with City Administration. Talking about which I agree we do, and when a council person comes on board, they need to be aware that those are the aspirations, right?
Yeah,
But
this is like the preamble to this paragraph.
yeah,
Are you saying it should be somewhere different, or are you saying something different?
it doesn't fit the title of the section.
Well, it does in the sense that they're tying these two things together,
Okay.
but not, you're right, not in the first paragraph. It says, it's almost going, well, before we get to the administration part,
Although it says you'll collaborate.
yeah, right, that part, that is. It's an expectation, and then the second paragraph is, okay,
Gotcha.
here we go, this is what we're gonna do.
Okay.
I guess, Councilman Cobb, what do you think? Curious.
I wish it had a different title. But I don't know what that other
How
title
about
would be.
expectations and interactions?
Should we move it somewhere else? Same language, but somewhere else?
That's,
Council interactions.
I mean,
Relationship to administration?
relationship and interaction.
Because most of the time when we've got a situation where a resident's asking for help, we have to collaborate with the administration in order to get a response. So,
Or collaboration with?
When you're done, I had a comment, but I don't want to
I'm done.
interrupt. So I'm looking at the second paragraph, and again, I guess I'm planting this seed now, expecting that we may want to raise this question again later. I think that there is some potential destabilizing. There are some potential destabilizing effects that could result from council or the president or a committee chair requesting a person who may not be a department head to appear at a meeting. Because you can, envision a scenario in which, first of all, it can make it uncomfortable within a department, probably less in mine, for example, than some others. But you also may have people who don't like their director, who are having a hard time with them, but they've, run into a council person in the hallway and, commiserated a little bit. And you can see how I just would say that there's the potential for abuse, and it might be better to see if that can be streamlined sort of through the normal city reporting and organizational structure. Meaning department heads typically would be the people who would be coming to talk about certain things in a department. And I think it would be legitimate to ask if there's another employee who can come, if there's a particular project or function that they're involved in more so than the department head. But just the way it's written, it looks like you could reach right down, and require a secretary to show up and spill the beans about whatever's happening in the department from their perspective.
But there's other guardrails in the charter that separate those powers out. Article 4 says, the administration has dominion over blah, blah, blah,
Right, and this is,
in conflict with that.
yeah, I think so, and you could have a certain amount of conflict, but I think you ought to make them, a court in construing provisions that aren't all like fully consistent. We'll try to do that in a manner called in pari materia, which means put it all together and try to define the actual meaning and to make them all work together as much as possible, to achieve the intended outcome. So all I'm really saying is just I think that second paragraph might be a bit broader than would be ideal for the city's operations. I'm not trying to take anything away from the authority that this would give to council to require an appropriate person to come in and talk with them. It also doesn't seem to provide any, and maybe the answer to this is that council can't discipline an employee, right? But it doesn't provide any wiggle room for you're requesting somebody to appear who doesn't appear then. What's the outcome then? If there's no outcome, this isn't all that enforceable. But there's nothing here that says that. I think council could excuse it, but you might just want to address something like that. Somebody could be sick, an emergency could come up.
Yeah, I wrote, or representative when not available or something, there does need to be something in there.
Doesn't designee work?
Let me read it again. Oh, you're not saying designees in here, you're saying add that?
In terms of, instead of representative,
Yeah, designee.
because we're seeking information.
Yeah, right.
And
Designee is the proper word,
yeah,
probably.
where we're trying to get it from a department, we should be asking the director, making the director aware of our request for information.
Can I ask everybody, can we take a 5-minute break? Is that okay? We're all agreed? All right, thanks.
Where is representative?
He's suggesting us to put it in,
Instead of person, and request the administrative officer to attend. When the council has made such requests, the administrative officer shall attend the meeting. I think that an administrative officer is someone that, oh, we took a break.
Yeah, why don't we take a break? Actually take a break.
Did she go home this evening? Is that what's-
Yeah, he doesn't work Wednesday evenings, but we really had to fit this in, so. So it's being recorded, it will be posted at a later date, hopefully tomorrow.
So he'll edit it?
Yeah,
Yeah, I am not able to sign on to the city internet for some reason. It is very weird.
it was doing that to Gail the other day.
Was it doing it to someone else?
It was doing it to Gail the other day, but
here in this room.
Yeah.
No internet. Now, I can
So-
get on the public, but I can't get on this.
And you wanna
So
be-
I am on the employee network. I guess one of the differences is that you two have the same device. Are you able to right now?
I'm on my hardtop, but desktop,
Which
see.
Wi-Fi network are you on?
it's what Addie set up for me.
See,
did it work when I did that the other day?
Okay, so you do have internet, but in the lower right-hand corner.
on this thingy.
It's not, yeah, see, it didn't ask me for my,
You're on employee.
Okay, I am too.
it didn't ask me for,
That is so nice, Addie. Can you let
I know.
my email?
for my,
May I?
my, yes, you may.
Did you reset mine so it works now? Is that what you did the other day?
I just made sure it was signed on.
And it looks like I'm not signed in because it won't let me get my emails either. You know, they had to go down. No internet.
Do you have a password on your computer?
Yeah, that's how Addie set me up.
Okay.
Yeah, and then
Do
she
you
linked it.
do you have like the password? Are you able to? I do not have the password for mine.
How do you get in here? You just don't have, they bypassed it.
Well, there is no password to turn it on, but then I can't do anything otherwise. Maybe they give it to me, but they didn't whenever they gave the device to me.
Wait, so how do you, the device is always on then?
Well, it's not always on, but so whenever I turn it on, anyone can open it, which is
Anyone can open it and get into it.
yeah. Well, I guess actually that's problematic because it's tied
Yes,
to my
it is
email.
problematic.
Yeah, you should have to enter
But-
your city.
Password.
Yeah, yours is really not working.
But I'm not. It's like pretty locked down, and I don't have that password.
I'm gonna turn the computer off and sign back
access.
on.
Yeah, you should have.
We'll see what
I
happens.
think that
What if you
I
left
might
that
have to
sitting
go.
someplace and
So wait until that starts working.
you would do that, but what if you do it?
I think that I might need to stop down to the lobby.
All right, so can we get down to like wording here? Is there, so,
Well, why don't you say we're back from our recess?
we're
or
back from our
our
recess.
break.
Thank you. And just to get down to wording, Mr. Law Director, what wording changes in the second paragraph would take us out of conflict with, anything in Article 4?
I plan to come up with something brilliant when this comes back to law.
Oh,
No, I really wanted to just sort of raise the question to sort of hear what folks thought. And I think that you can have certain inconsistencies, including in some cases in one provision, you can say except as provided in section X of the charter, blah, blah, blah. Or subject to section X of the charter, and then, make them work together that way by providing explicitly that they're supposed to work in tandem.
So is or designee, does that work in the last sentence?
I'm not sure about,
Okay,
but I made a note
okay.
about designee. And at the end of this section, another question I have, I think I know how it's supposed to be interpreted, but it says when the council president or committee chair has made such request, the official, et cetera, shall attend the meeting and answer questions asked by any member of council related to their powers and duties. Is that the employees' powers or duties or council's powers and duties? So I think it could be made clear so that nobody has to get
Yeah,
hung up on that.
Related to the officials' powers and duties. But going back to this,
That's what I think it probably means, yeah.
right, so but just to change the officials, but you stepped out to go to this and administrative officers and employees. So how about to limit this a little bit? The mayor, city administrator, and city administrative officers shall respond to. I think it should be a little bit narrower than opening it up to employees.
Agreed.
And a city administrative officer shall respond to inquiries from city council members in a timely manner. And then may request an administrative officer to attend specified meetings of council or such committee respectively. And then when the council has made such request, the administrative officer requested to be in attendance shall attend the meeting and answer questions asked by any member of council related to the officer's powers and duties. Because I guess I have a concern if we're opening this up to bringing a police officer in or a secretary or something like that. I think that's too broad. And jump in the chain of a command.
I mean, Lakewood did that by ordinance
Bring it in
with the employees,
too.
yeah, they did it. I mean, I can't make a compelling case right now why that ought to be in there. But let's just say a council, thought that this was too narrow with just the directors. It could feasibly be done by ordinance to include employees.
Maybe.
Am I wrong?
Well, I think then you have to look at the other provisions of the charter that otherwise limit it. And there's also the subpoena language that you spoke about, which there's different provisions that could touch upon related types of issues.
All right.
And I think with respect to removing employees, that goes to the point that I was initially raising. I think that's a good idea. But I think it's also worthwhile thinking about what does city administrative officer mean? I'm not sure I know the answer to that. So I just think you'll want this to be clear when, if this goes to the voters.
Department directors, chiefs, I think it should be.
That's
I
probably.
mean, it should be spelled out, whatever.
Right.
Those, because if you
I think
use
that's the most appropriate level.
yeah, you can't use a euphemism because then it's like nobody's gonna know what that means.
And our intent here is to get information
Yeah.
that is in the confines of the department that we're wondering about, we're questioning on data, whatever. The intent is to not be punishment.
Right.
Or overreaching at this
Well,
point.
That's a good point. I think this is about two things from my point of view. This is about inquiry and having it be satisfied that council needs the information and they have a right to get it, and it's very clear that they're compelled, the administration is compelled to give it. That's the second paragraph. The first paragraph is about
Kumbaya.
an aspirational relationship between the two branches of government. And I think that's why that title is difficult, because,
And if you did make the change to directors and chiefs, for example, in that third
Yeah.
clause, I think that's the point at which, or their designee, or the designee of any
Right.
of them, whatever, because that way they're making that decision. If there's somebody who's better to be appearing in front of council than them, they can send that person.
I mean, what we want to avoid is basically what happened the first 2 years, which is, any kind of argument about except for inquiry. I don't want anybody to look at this and go, I'm not sure if you have the right to get your questions asked and answered. I don't want that to be like a jump ball anymore. I don't think anybody does. Anybody on council, I can't speak for the administration, but so to the degree that this makes it clearer, I'm all for that.
Okay.
And, the employee thing, I don't know, I'd almost want to talk to somebody from Lakewood just to see if there's something they know that I don't know, like why that's necessary.
Yeah.
And if it were, even if I was convinced, I don't know, I don't supposed to speak for anybody. If I was convinced, well, there's two other issues, the one Bill brought up about, it's these amendments we talked about today are interactive. And we got to make sure we don't do something that makes it difficult to, for the amendments to work together. And then the other part is, then if that's okay, are there things we can do through ordinances that would not be incompatible with, in the future? I don't want that door to close either, because we did something here that won't allow us to do something that might go beyond this. Or, I'm not even talking about this council, but just a council in the future. We don't want to make it so they can't do something that might benefit the city to have council have, because this is what we're talking about here, is council's powers in this section, in this article. So I have nothing else to add, though. I think these are good amendments. Are you comfortable with it being narrowed down to, at least for the time being, chiefs and directors? All right, Article 4, we got about, if we go to 8 o'clock, is that what everybody wants to do? No, I mean, cut it off at 8 o'clock? You'd cut it off. Yeah, okay, but
It's been a long day.
I have to ask members.
Understood. I'm not on
Are
the
we-
committee.
Are we okay with knocking off at 8?
I assume that was.
Yes.
Another half. Another half.
At 8, nothing further.
No, we'll like 5 till Addie will go, hey, guys, we gotta
You got it.
wind it up. So the next is Article 4, the mayor. You see what was crossed off as far as 4.1? Yeah, we kind of don't need that last sentence anymore. I guess that's why they cut it off. Qualifications, anybody on 4.1?
You don't need it. You do see those relics in lots of charters. I mean, you
Yeah.
don't really cause any harm.
But that thing about when it started, we don't need to do that anymore. 4.2. As far as the qualifications go.
Oh.
All that stuff about the school districts, what did you guys make of that?
Well, it wasn't changed.
I had a question for you on that on council. Did you guys already deal with that?
What-
Deal with
Sorry,
what?
back, Section
qualifications for-
3.2.
3.2.
Oh, for qualifications for council.
And this may be written up, but I didn't know why the provisions about a council person not being able to be an employee of the city is left, but then the school district or the East Cleveland School District, why that was removed. Because I think that situation could lead to a lot of conflict, which I think is why it's traditionally in these
Oh, yeah,
provisions.
I missed that completely when we went over it.
Yeah, I just was reminded
Yeah, I
of
don't
it
think we
because.
ever brought that up when we went over it the last time.
So I don't know that, you don't have to get into it tonight, but I just wanted to at least make that placeholder. I feel like that's a question worth working through.
I think it should stay in there because there are situations where there is or could be a conflict between what's in the city's best interest versus the school districts.
That's pretty
Right.
obvious, actually.
Yeah, so I don't know why it came out, and it's not just like on the board, et cetera, but like an employee. And so then they could be subject to pressure from the school board. It's, I think those should stay out.
Yeah, I'm good with that, everybody? Yeah. And we did change it from 6 months to 1 year, did we not?
That was
Yes,
the discussion, I
yes.
remember, yeah.
Residency. Everybody was good with that, because I wrote that down and checked it off.
Okay, sorry for that.
No, thank you, because that, okay, so now that answered my question for the qualification thing here. It's funny, the mayor of Eastlake, I believe, had to resign today because he had another job that was considered a conflict. And I don't know if he was forced to resign, but that,
Yeah.
you don't want, what happened there today, you don't want that happening.
In scathing letter.
It was he had a second job, that's what it was. It was a second job.
All right,
And-
keep it on track, keep it on
Yeah,
track.
okay. Well, I mean, it's, what do we want to have
Yeah,
in here
no, I
to
think you all
make
agree.
sure that those things don't
Yeah, I
happen?
think you all agreed to keep that.
Um,
4.3 is.
yeah, 4.3, I have some notes here. I mean, we certainly know that the mayor is required to keep council fully advised as to the financial condition and needs of the city, just from the original language. What do you think about what was added here? The mayor shall prepare and submit any reports required by council. The mayor in a timely manner shall exercise powers and perform duties conferred upon or required of the mayor by this charter, by ordinance, or by general laws.
It makes sense to reference the charter in the Ohio, the ORC in this section.
I think ordinance is the trickier question.
Here's the thing, we pass ordinances and then sometimes, we're waiting, we don't see stuff. And without a requirement, this kind of gets almost back to oversight in a sense. I know this is Article 4. Maybe this belongs somewhere else, I don't know. you see what I'm saying?
Does the second sentence of that red text in the middle of the paragraph,
The general laws of Ohio.
that the mayor in a timely manner shall exercise powers and perform duties conferred upon or required of the mayor by this charter, by ordinance, or by general laws? Because there's a theory under which the mayor shall prepare and submit any reports required by council, could contemplate motions, could contemplate, lots of requests or requirements for reports, where the formality of doing it in an ordinance doesn't deprive council of that authority, but it requires a little more formality, and there's a process for dealing with an ordinance. That's all. I'm just throwing it out there for your consideration. Because just like writing a job description, charter provisions shouldn't, it's not about any individual person, it's about a position. So that's what led to my question.
Is there some redundancy in that? Is that what they're trying to
Like-
refine, is the redundancy? I'm just trying to understand why they interjected that sentence.
Well, I would guess that they did it to make it clear, clear and definitive, but, I don't know.
Because they talk about exercising powers, performing duties conferred upon and required of the mayor by this charter, by ordinance, or by general laws, and then in the paragraph above, it also talks about, well, then it's specific to the mayor's director of public safety, so I'm just feeling like there are more words in this paragraph that cause more confusion than clarification.
My issue is the lack of use of the Oxford comma, but that's besides the point.
Lack of these.
There should be a comma.
President Kudo,
Yeah.
did this section get rewritten when the mayor came on board and the other council person went through the whole charter and made adjustments? Because we were now a mayoral form of government, not
Council person.
the lawyer that we had before you.
Well, we did this. Law department worked with Luke,
Yes,
who was in
Yes.
University Heights at the time, but also at Nicole Branson and Cooper.
yeah,
No, there's no authority for council can't change this directly. So what we were doing was recommending changes to the ordinances,
okay,
right? Because this can only happen through a vote of the electors.
People.
Yeah.
okay.
I have to say, it would have been instructive for me to have, for this section, to have reread Citizen for Elected Mayors. It's just not something I actually thought about beforehand, but that would answer this question you just asked, but also as we go over the rest of this, I'd have to, we did that like 5 years ago, so.
Yeah, even more. It was headed to the ballot.
That's true, yeah. That added part in red, the two sentences. I understand the purpose of it, that's clear. Is it redundant? I don't know.
The commission wrote that they felt that the red section, the added sections, they add qualifications to the mayor's control over departments due to changes in section 5.2A. And they also, their wording adds requirement that mayors submit reports, because that's one of the things that we're looking for is periodic reports from different departments, required by council and perform timely duties conferred by the charter, ordinance, or general laws. Deletes reference to affixing the seal, no longer the practice. So they were intentional, commission was intentional in this section to make sure they clarified what they felt was not clear. I'm fine with it, I guess.
Anybody else? Okay, I'll move to 4.4. I actually want to talk about 4.4 a little bit. So this has to do with the city administrator. It's my feeling that when it says, actually, it's the first sentence. I have one question. Okay, so city administrator shall be appointed by the mayor on the basis of executive and administrative training and experience subject to the confirmation by a majority of council members or members of council and shall serve at the pleasure of the mayor. Okay, I think this is a little bit loose, the experience part. I think the experience needs to be related to municipal operations. I just find this like, that's just too broad for me. You know, to me, you know, I know what the intent was. I know precisely what the intent was. So I could talk about that. You know, there was concern about deprofessionalizing City Hall. You know, so this is where the position came from, and it's also where the, if you will, the job description came from. And the job description was, the spirit of the job description was the ability to run day-to-day operations in a municipal government. And this is too loose for me. I think it should say experience related to municipal operations. I know.
How much experience? So,
See,
for example, Danny Williams, would his tenure as the law director of City of Cleveland meet that experience level? Or is it actually the experience that he obtained running other large enterprise organizations?
well, that's the thing. I say municipal operations, and you know, I don't want to get down to how much. That's too granular. But
Sorry, for clarification, are you saying in addition, add that to what is already here or replace what's here with that? So are you suggesting something like on the basis of executive, administrative, and municipal training and experience, or replace it with on the basis of municipal?
well, I
On the
think
basis of executive and administrative training and experience related to municipal operations.
an experience, yeah, related to municipal operations. Yeah. This isn't just about training and, you know, some kind of training and some kind of experience. You know, I know why charters are broad, and I totally get that. But to me, this is a luxury in the grand scheme of, you know, the 58 municipalities in Cuyahoga County, you know, this having a city administrator, in the sense that, you know, I can think of one that does and 57 that don't. No, I'm sorry, Cleveland does. But, you know, there's a chief of...
Middleburg, I think,
Really?
and Shaker, right?
Shaker, yeah. I didn't know Middleburg did.
Bob Downey, I think, is in that role.
Yeah, although he's leaving.
He's gone,
Oh, is he?
retired now, yeah.
They probably, I'm assuming they replaced him.
See him in Starbucks.
I'm sure he's happy to be retired.
It's for all retired people doing it.
So are you thinking of a generalized, I know we had a little discussion about this, but are you thinking of a general discussion, reference to that type of qualification, or are you thinking of like an ICMA certification, prior employment as a city manager, chief administrative officer, some specific?
I want mayors to look for people who have municipal operations experience, not people who have some training and experience, general training and experience in who knows what.
So does a law director qualify for that, to Councilman Cobb's question?
I mean, it is
I have my own opinion, but.
it is municipal experience in at least the operation of a department. You know, that's something. I just find it. I find this too loose, too broad. I don't want mayors to have the leeway to hire people who, you know, it's like, okay, and I know that like Kennedy went out and got the guy from, you know, who ran Ford to be the, you know, I mean, okay, I know that's what, I don't want this to be like that, you know, to run the Defense Department. That's getting kind of weird, you know?
Is that McFarlane?
McNamara, it's very good. I really do
It was a
appreciate
Mick. MC.
Yeah, I mean, it's just, there's a point where it's just, you know, then you're not accomplishing the thing that you want to accomplish here. Now, if we disagree on what we're trying to accomplish here, let's start with that. Because, you know, the mayor was supposed to be the vision guy, or you know, man or woman, and you know, doing the big picture stuff. And there was supposed to be somebody who's gonna come in that knows how to make the trains run on time. And in order to do that, I mean, you could argue that somebody that if you think it's transferable, that somebody who was, you know, running a company, you know, making the trains run on time in a company could come in and do this job. I mean, make that argument. I think this is a pretty specific skill set that I don't know that people who just run stuff are gonna be able to come in and do, but I'm certainly willing to listen.
I would agree with you. If you look at the next paragraph, when they look at what's required of this person, it seems like they should have a knowledge of the structure of municipal government coming into this position. I mean, it justifies it.
So question, I asked an earlier question about,
Yeah, I'm saying just add.
Yeah.
so basis of executive, comma, administrative, comma, and municipal training, would that satisfy people's like interest here?
Municipal operations.
And then it would sort of be at the discretion of the mayor when choosing someone, whether someone like Danny fulfills that. I, like the law director, have my own opinion, and then council could decide for itself whether it feels that person's experience is sufficient.
So the mayor could still go out and hire anybody they want. You know, this wouldn't stop them from doing it. But if I were gonna vote, I'm just talking about from a council perspective, if I were gonna vote against it, I would wanna have a basis to do it if it was, you know, not just go, well, you know.
It says
he thinks this,
municipal.
He thinks this and,
Right.
or she thinks this and I think that. Go ahead, Annie, I'm sorry.
I was just trying to figure out if the way that you worded that would preclude someone who has municipal experience. Never mind.
Well,
But
I
like
mean,
without the necessary like administrative training, right? So if you've got,
I think that a mayor could argue, even if we say executive, comma, administrative, comma, and municipal training and experience, I think that you could have a mayor who chooses someone with no municipal experience and says, I'm choosing this person because they have no municipal experience. This is someone who will bring a fresh perspective. So I think that even if we added that, it wouldn't preclude someone from being nominated who has no experience.
I want to encourage the mayor to hire somebody with municipal operations experience, and I want to encourage council in this amendment to want to confirm somebody that has that experience. I want to encourage it on both ends with some language that pushes it a little bit further than it currently does.
Why I would suggest what I said earlier, what you kind of hinted at, which is basis of executive and administrative training and experience related to it. So it's
And relevant
related to municipal operations.
municipal operations experience. I mean, I don't have the words right now.
Let's just come back for wording, guys.
Yeah, but just,
I think you all agree that you kind of want something that's more specific to municipal.
I mean, maybe we just leave the wording to the law department, but I want to see if there's agreement on the spirit of it.
Yeah.
Yes.
He's having,
I think I'm gonna differ on this a little bit. So you
Over here.
could have someone that has worked for the state of Ohio or the county and does have experience similar to having worked for a municipality by virtue of having worked for a political subdivision of the state of Ohio. I think it is up to city council members to determine whether that person's training and experience meets their qualifications. And so now is an ideal time to say to the mayor, you're looking for somebody. If you want confirmation by this city council, I've conferred with the city council members, and we want someone that has got some municipal law experience or this.
municipal operations experience.
But, you know, you could have somebody that's got county or state experience that would
No, that's a
fit
good
in
point. That's a good point.
and be fine.
So
The
maybe
pool
there's,
of applicants is going to be limited as it is.
we already can not
Yeah.
confirm somebody saying, well, that's not meeting the standard. What I want to do is encourage municipal operation experience in the charter.
And you also made a good point about, well, if I vote against someone, I want there to be a basis. You know, you don't want a situation where a mayor says, oh, well, it didn't say that this person needed to have municipal experience. You're voting against them for that reason, but that's not a requirement. But back to what you were saying.
No, I would try to find wording that satisfied.
Would the
your-
word like
Because-
government
No,
be
I would agree
sufficient?
with you. Well, operations, you know, the job is I understand it. And I understand that not everybody's gonna go, okay, this is what a city administrator should do. But the way, I can tell you that there were 10 people on a committee that said, we want a person who can run day-to-day operations and make the city efficient and, you know, innovative and, you know, not the person that's charting the direction, you know, not that person, but, you know, the day-to-day operational stuff that goes on that doesn't, you know, need the mayor micromanaging, for lack of a better term, you know, all that stuff. So if we got that person,
Sorry, I didn't mean to interrupt. So a few years back, I worked with the city of Greene on their charter review, and a lot of that came out of a charter amendment that made the position of director of law there an elected position, which led to the departure of the prior director and election of somebody. But it didn't really work with the rest of the charter, and so they undertook a full charter review to synthesize the different pieces and parts. One of the questions that came up during those discussions had to do with the director of law and how much experience they should have and should they have municipal director of law experience. And so what they ended up with, for some of the reasons that Councilman Cobb was mentioning, was, and this would be a little bit different, but for what it's worth, for director of law, first elector appointed after January 1st, 2020. So not trying to disqualify anybody, they shall, for at least 2 continuous years, be a qualified elector and resident, and be an attorney who is licensed during blah, 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 and have a minimum of 5 years of employment or public practice experience in municipal and or other governmental law. So they tried to make it specifically governmental, but to, include municipal, because that would be like an important,
Yeah.
potential benefit, but to leave it broader as well. And also not to say they had to be an employee, but it could be a public sector practice that a lawyer was engaged in those areas. So if that's,
No, that helps, but Craig, I agree with you. I mean, I wouldn't want somebody who was like operational county, experience, government experience to be excluded, at least in the language, so.
So based on what the law director just shared, what about something that says on the basis of governmental executive and administrative training and experience?
Yeah, that sounds about right.
But then does that preclude people who do not have it? Well, again, that goes back to what I was saying earlier. A mayor could say, okay, I'm choosing this person because they don't have that.
Well, or they could just say, well, they have 2 out of the 3, people often don't have, cover all the bases.
Well, we wouldn't be adding something new here. We're just like clarifying this with an adjective, governmental, executive, administrative training and experience, and not executive, administrative, government training and experience.
and you could do the same kind of trick, like municipal or other governmental, if you want to at least get that word in there.
Ooh.
So you're not limiting it, but you're emphasizing.
Yeah.
It's important.
It's
I kinda like
the
that.
main, it's operations, they understand operation. That's they're the COO, they're not the CEO, and if we can make that clear, and, again, we don't have to finalize the language now.
Yeah, I'm gonna write down a few of the options we were talking about.
Okay. We're down to the last few minutes. Can I bring up one other point in this particular? So I don't understand why they crossed out the preparation of the annual budget. I do understand that, I just think, when I think of operations, this is the second part of, no, we're still on the same 4.4. We're still on 4.4. So what's crossed out is be responsible for the preparation of the annual budget.
I have an answer to that.
Okay, go ahead.
It's from their document. It deletes the requirement in the second paragraph of 4.4 for the city administrator involvement in budget preparation because Article 9 calls for the mayor and the finance director to submit the draft budget.
So that was a inconsistency.
Yes.
Okay. It doesn't, that doesn't stop the law director from, or it doesn't stop the mayor from asking the law director, hey, can you help me out with this?
You mean city
You mean the
manager?
finance?
Administrator, finance.
City administrator, sorry.
No, I think that's right, yeah.
Because, we wouldn't wanna. Okay, that does make sense. And since we're gonna have to knock it off in a couple minutes, anything else in this 4.4?
Yes,
Okay, go.
they deleted the requirement of 2 reports. I can't tell you how much information I learned for the first time from Danny Williams'
Yeah.
report. And I think that we need to get that kind of information and update with that kind of detail twice a year.
And here is their rationale, but I would agree with you that it should be semi-annual. They said they revised that requirement in the 4th paragraph for a city administrator's report semi-annually to require annual report in September to coordinate with the budget process.
No, that I get, but why
Why
once a,
delete?
you know,
No,
why?
I think it should be semi-annual.
I don't have a problem with it being September being one of the dates, but
Well, then the
does
other-
anybody have a problem with that? But
This is frequency.
twice a year,
Yes,
you know,
So
absolutely.
it'd be March 1?
March and September.
now what happens in the case of, like, what if, let's just say somebody got hired in February, you know, I mean, do they have to have a report in March? I mean,
No.
March 15th.
Well, I also think the March 1st makes sense if we're talking about how that's usually when we do our wage and salary ordinance.
Yeah.
So, put that out there.
I mean, that has to be considered, but
And we could just leave the word periodic in there. Not define it. But then that doesn't help either, does it?
no, I mean, I can tell you, we never got a report from the first city administrator.
Right,
And,
we needed that.
you know, Mr. Williams did wait more than 6 months to do a report. And that, it's not a criticism, but it's, I mean,
Periodic seems like it would be fine so long as we kept not less often than semi-annually.
Right,
I don't want less.
Maybe we should keep it how
Just
it
keep it
was.
how it was.
I mean, I'm not for less, you know, 1 year, no. I'm not for that.
You know, it previously said periodic, not less than.
Yeah.
Mm-hmm.
Yeah, that's not something I'd want to change. Is there an appetite to have one of those reports shall be September? Because that would not make the other report have to be at a certain time. But one report would have to be at a certain time. If we think we need that report before the budget, I don't know.
Yeah.
I mean,
I would just leave this as it was previously and ask as part of the budget process. Doesn't need to be baked into the charter as part of the budget process. We'd like an update from the city administrator in September. So it would be a very easy job for that person to update their last report to us, or they can adjust it however they see fit. Ideally, we'd be getting a monthly report from the city administrator in a perfect world.
right.
And we could always pass an ordinance to, if it's the case that they're not like delivering it around that time, and we
I was
realize that we want it, we could pass an ordinance rather than locking it in the charter.
But we'd have to have the language be not,
You'd want to make sure it worked here, that you were authorized to do that.
right, so like at a minimum of, you know, so that we are
I
a
mean,
maximum.
you could put something, you know, or at such other times as prescribed by, reasonable times prescribed by
Right.
council.
I've seen that, and that's all over charters, that kind of language.
Yeah.
Yeah, did you get that? That's such an important tool that could be used, that we could use throughout the charter.
It would preclude us not having to have employees come into meetings.
Well, just that whole part about or as prescribed in ordinance, I mean, maybe not those exact words, that's really important tool in a charter.
And you might have a limit there, like, so you can't go crazy with it and
Right.
abuse it, but, you know, whatever.
Not to exceed. All right, I think we've done 2 hours. Thank you, everybody. I know this is really laborious. So this meeting, without objection, is adjourned.